Hi there, and thanks for joining our short course on freedom of speech. I'm sure that you've all heard the terms freedom of speech and freedom of expression, and we can all probably give a pretty good definition of what these mean. But we want to make sure through this short course that we all understand what freedom of speech means at university and how that contributes to the importance of free and open debate in higher education. So, for the next few minutes, we're going to cover some of the headlines and some things to think about. The University of Birmingham is an academic community of staff and students, a place for open, critical thinking and the creation, sharing and dissemination of knowledge. We are a university that teaches, researches and applies knowledge in a comprehensive range of subjects. In this environment, academic freedom and freedom of speech are fundamental, and that includes challenging other views and putting forward ideas that may sometimes be radical or dissenting. We are committed to securing and promoting freedom of speech within the law for all of our community, staff, students, and visiting speakers. But what do we mean by within the law? Well, freedom of expression, which includes freedom of speech, is a fundamental human right that is legally protected by Article 10 of the European Convention on Human Rights. This is incorporated into the law of the United Kingdom via the Human Rights Act 1998. Article 10 of the European Convention on Human Rights protects your right to hold your own opinions and express them freely without government interference. This includes the right to express your views aloud, for example through public protest or demonstrations, or through published articles, books or leaflets, television or radio broadcasting, works of art, or the internet and social media. Provided the speech is lawful, the right to freedom of speech protects views that may also offend, shock, or disturb. Curbing speech which is merely offensive does not uphold freedom of expression. However, freedom of speech comes with responsibilities and is therefore a qualified right. There are categories of unlawful speech which are not protected by law. The European Court of Human Rights has held that expression that promotes or justifies, for example, violence, hatred and xenophobia cannot normally claim protection of Article 10. In addition, universities in England are also subject to the Higher Education Freedom of Speech Act 2023, which strengthened rules to ensure that campuses are places where robust discussion can take place. At the University of Birmingham, we have embedded these legal duties into our own ordinances and codes of practice. That means the rules and regulations that the university and staff and students must follow. That includes special protections for academic freedom. Academic freedom protects the intellectual freedom of academics to question and test received views and wisdom, and to put forward new ideas and controversial or unpopular opinions without placing themselves in danger of losing their jobs or privileges. Universities in the UK have a legal duty to ensure that ideas and opinions, however unpopular, are allowed to be expressed freely, so long as that expression remains within the law. The university stands for the broadest definition of free speech, and we have to be able to disagree and have conversations about sensitive subjects in a constructive way. It's possible that at university you may hear and discuss ideas and research topics that, whilst lawful, may be unpopular. They may even be offensive to you or someone you know, so we need to be open to listening to ideas even if they're ones we don't like or don't agree with. It's important to recognise that these can be complex matters requiring difficult judgments, and not everyone is going to agree on these. For events and debates held on campus where we might invite a visiting speaker, the university's starting point is that the event should be permitted to go ahead, unless there are demonstrable, lawful reasons why it must not. In some cases, the university may need to use its judgment to determine what is lawful or not. It is a difficult balance, and now I'd like to give you an example. Imagine there's a classroom. The topic of the lecture is a sensitive issue such as an international conflict. During the lecture, A student expresses views which the lecturer and some other students find upsetting and offensive, and which reflects one side of the conflict only and ignores the opposing views. This is what we need to consider. The university has a duty to secure freedom of speech, including in teaching settings. The student is entitled to hold and express their views, and so is everyone else in the room. Individuals have a right to freedom of thought and expression, and a right to religious thought and philosophical belief. So, in dealing with these conflicting and sensitive views, the lecturer might facilitate a discussion on the topic, inviting different views to be heard within a constructive debate. Or, the lecturer might support students to enable them to disagree well, for example, with ways to present evidence and rational argument for their views. The lecturer might also guide students to resources which enable students to prepare for sensitive or contentious topics, or may arrange to speak to students separately so that the lecture can continue. Under the Equality Act 2010, students are entitled to protection from discrimination based on, for example, their religion, if that arose in the lecture. And examples of hate speech are not permitted under UK law, including expressions of hatred towards someone on account of their protected characteristics, and any communication which is motivated by hostility or intended to harass or distress. Freedom of expression also protects the right to protest. This is an essential part of a functioning democracy and academic debate and challenge. Everyone has the right to peaceful protest, so long as it doesn't break public order laws, restrict the right of expression used by the speakers, and does not threaten or harm them. The university has a process for groups to apply to hold an event like a protest or rally on campus. The university has to comply with its legal duties to ensure health and safety and public order, to consider any visiting speakers, and to protect everyone's right to freedom of speech under the law. Typically, the university enables all events to go ahead. Sometimes there might be additional conditions attached to an event in order to balance these factors with the aims of the protest. The university is subject to legislation, regulations, and guidelines to ensure that all lawful views are allowed to be expressed. The university has a code of practice that sets out our values and approach to protecting freedom of speech. The code of practice also outlines staff roles with responsibility for implementing the code of practice. You can find the link to the code of practice below. That's already quite a lot, so check out the links to further resources below that you might find interesting. Thanks for listening.